I'm Rebecca Zitlow. I'm the Dean of the College of Law. And welcome to the 54th Annual Charles W. Fornoff Competition. This is such a special day in the College of Law. We have judges coming in from Michigan and Ohio, from the federal bench and the state bench. We have 4 of our top students that are going to show you their oral skills as they argue this important case. And this is all brought about as a result of the Moot Court team, the Moot Court coordinators of Kaylin Hunt, Matthew Sheneman, and Andrew Etherington. There he is in the back, yes. So let's give them all a round of applause. Also, I want to give a huge amount of thanks to Professor Glennis Spence, who is the director of our Moot Court program. Let's give her a round of applause as well. And to all the Moot Court members, Katrina Adams, Olivia Butler, Andrew Etherington, Jacob Kirkpatrick, Andrew Matrano, and Nick Randall. Let's give them a round of applause as well. I'll be honest with you, we're not quite ready to go yet because we are awaiting one judge from Michigan. Do we know what his status is?
He's on his way.
He's on his way. So we will be starting more momentarily, but I just wanted to take this chance to welcome all of you, and we will begin the proceedings very, very soon. Thank you.
All rise. The judges of the Court of Appeals for the Sixth Circuit of the United States are now in session. Oyez, oyez, oyez. All persons having business before the Honorable Sixth Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The Honorable Judge Hood, Judge Knapp, and Judge Miley presiding.
Please be seated. Bring mic up, guys. Good afternoon, everyone, and welcome for the continuation, the final session of the Fornoff competition. We will jump right into it. We're calling item 1, case number 24-CV-945, Katrina Zuniga versus God's Grace Church. And counsel, before you get started, please make sure to place your appearance on the record, speak in the microphone so that everyone can hear everything that you have to say. We have a separate timekeeper, but I would just ask that if you're reserving any time for rebuttal, please make sure to let us know. I'm also perhaps got into it a little too cold. Let me introduce the bench. Sitting today with Judge Knapp. Actually, can we each make our introductions ourselves?
I'm Judge James Knapp. I'm a United States District Judge for the Northern District of Ohio, sitting at Toledo.
Judge Christine Miley. I sit on the 6th District Court of Appeals in Toledo.
And my name is Noah P. Hood. I'm a justice of the Michigan Supreme Court. Previously, I used to practice here in Toledo at the U.S. Attorney's Office. Counsel, with that, the floor is yours.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Amanda Wendt, and together with co-counsel Haley Bennett, we represent the appellant, Ms. Katrina Zuniga. May I please reserve 2 minutes for rebuttal?
Of course.
Thank you, Your Honor. Before I proceed, would you like a brief recitation of the facts?
Not necessary for me, but perhaps.
I don't believe so.
Okay. There are 2 issues before this court today. First, whether the ministerial exception creates a categorical bar to a minister's hostile work environment claim under Title VII. Second, if there is no categorical bar, is there a genuine issue of material fact as to whether the alleged harassment was sufficiently severe or pervasive to create an abusive working environment, even after the tangible employment actions protected by the First Amendment have been excluded? My co-counsel and I will address each issue in turn, and I'll begin with issue 1. One, and perhaps the only common denominator among all case law on the ministerial exception, which was established in Hosanna Tabor, is that it bars claims by aggrieved employees involving tangible employment actions. A tangible employment action is an official change in employment status. In contrast, intangible employment actions involve non-economic harms, such as harassment and emotional distress. In Hosanna Tabor, Chief Justice Roberts specifically noted that the court was not deciding whether the ministerial exception bars other types of suits. 8 years later, in Our Lady of Guadalupe, the Supreme Court expanded who the ministerial exception applies to, but it did not expand when this exception applies.
Counsel, let's say for the sake of argument that I agree with you or that I want to agree with you about this. How do we draw the line where we are able to vindicate rights and give teeth to civil rights legislation, but still not getting into the business of church operations and, church operations?
Absolutely, Your Honor. So this is an issue of first impression for the Sixth Circuit. Other circuits are divided on this issue, notably the 7th, 10th, and 9th circuits. The 7th and 10th have held that there is a categorical bar, and ministers cannot bring any claims, whether it's tangible or not. However, the 9th Circuit has held that tangible employment actions are barred, but intangible actions, as long as they do not involve church doctrine, can be brought.
Counsel, is a church's decision to not discipline one of its ministers a tangible employment decision?
Your Honor, it is our position that that is not a tangible employment action. The church did an investigation into this alleged harassment that Ms. Zuniga brought before the HR director. And as you said, they looked into it and found that there was no inappropriate action by their ministers. And they especially noted that these ministers were like high-ranking officials in the court in the church. And so they especially did not mean their comments in a demeaning way. Turning back to the conduct that Ms. Zuniga faced, the record at pages 10 and 11 indicates that Ms. Zuniga was subjected to sexualized and disparaging comments, specifically about how good and fruitful her body looked. Ms. Zuniga was compared to the wives of Eddie Lewis, Timothy Thomas, and Mark Adams, and these are her superiors in the church.
What's your response? Well, sorry, I didn't. Did you have more to say about that?
Yes, but
Go
okay.
for it. Go for it.
Ms. Zuniga was told that her physical traits were a gift from God, and these men touched Ms. Zuniga without her consent. Ms. Zuniga's case and claims mirrored those that were presented in the Elvig case out of the 9th Circuit, which held that there is no categorical bar to a minister bringing claims under Title VII to the court. The court in Elvig did acknowledge that a defendant may invoke First Amendment protection from Title VII liability if the claims the plaintiff is subjected to or the defendant's toleration of sexual harassment was doctrinal. However, the church in Elvig did not assert church doctrine as a justification for the conduct that Elvig faced, and the church here did not assert church doctrine as a justification for the conduct that Ms. Zuniga faced either. Religious organizations are afforded layers of protection for religious decision-making. Further, sexual harassment is not doctrinally based. It is not a protected choice, and it is not inherent in church administration.
Counsel, but here, the church did its own investigation and made the decision not to discipline its minister. So how can a court review this issue without entanglement with the church's First Amendment right to its own internal governance?
Absolutely, Your Honor. So the free exercise and establishment clauses of the First Amendment, rightfully so, protect churches from governmental entanglement. However, these clauses did not shield the church in the case of Bollard's claims against the church. Bollard was allowed to bring his claims when he asserted a claim of sexual harassment against the Jesuit order. Ms. Zuniga here is allowed to bring her claims because she The church did not assert a religious justification for their actions. The church is not exercising their constitutionally protected right to choose their ministers, and they're not asserting their behavior as a constitutionally protected religious practice. Looking at the free exercise clause, courts must weigh 3 factors: how much the law affects the religious practice, whether the government has a compelling reason for that burden, and whether giving a religious institution an exemption would interfere with the government's goals. Here, enforcing Title VII does not affect religious practices at all. The government has a very compelling interest in preventing workplace discrimination, and granting an exemption would directly undermine that goal.
Please. Well, counsel, let me ask, going back to where exactly we draw the line, do you acknowledge or do you concede that there are likely some Title VII claims that would otherwise exist with a different sort of employer that would not exist in this context? For example, if the church said, look, our religion dictates that a woman should not be teaching a man, and for that reason, we're not going to promote you to this level of teacher. If that were the case here, would you still be arguing that the claim could move forward?
Your Honor, if I'm not mistaken, that would be more in the realm of a tangible employment action, which is barred under the ministerial exception. So that would be a different circumstance, and we don't encourage the court to draw a hard line as to what is and is not covered here. We are asking the court to use the test that was established in the Elvig case, which looks at the totality of the circumstances. The free exercise and establishment clauses of the First Amendment uphold a core principle in which our nation was founded upon. However, what these clauses do not do is give churches blanket immunity to harass their ministers. The protections afforded by the First Amendment are not absolute. When Congress enacted Title VII, they did not intend for ministers to surrender their right to a workplace free of discrimination and harassment.
So then, counsel, in your opinion, do you believe that the government could force a church to adopt an anti-harassment policy to govern their ministerial relationships?
Your Honor, while I'm not sure that the government could force a church to adopt an anti-harassment policy, I do think that that would solve some of the issues we are here litigating today. However, those claims could not be brought before the court if it falls under a tangible employment action. So may I have a brief moment to wrap up? I'm out of time.
Yes, that's fine.
Thank you, Your Honor. Yes, we would be right back here litigating the ministerial exception. So, Your Honor, we ask that this court approach this issue with a Goldilocks judgment. The ministerial exception cannot protect everything. It cannot protect nothing, but it can protect the right amount. And we contend that the right amount is no categorical bar. Thank you.
Thank you, counsel.
Thank you.
May I proceed?
Yes.
Okay. Good afternoon, and may it please the court. My name is Haley Bennett, and together with my co-counsel, we represent the appellant in this case, Ms. Katrina Zuniga. As my co-counsel previously noted, there are 2 issues before this court today, and I will mainly be addressing the second one. This case asks whether there are sufficient facts in the record, viewed in the light most favorable to Ms. Zuniga, to create a genuine issue of material fact as to whether the experience Ms. Zuniga had while at God's Grace Church did rise to a level of a hostile work environment, and this record shows that there are. Under Rule 56, summary judgment is appropriate only when no reasonable jury could find for the non-moving party. When reviewing a motion for summary judgment, the court is to view...
Counsel, let's skip past the standard. We're all aware of that. Let me ask you specifics about your case. The facts here, I'm not quite clear on how exactly the timeline lines up for when this alleged conduct occurred. It seems to me that there are some specifics about what your client is saying happened, but when it happened and where the incidents fall in relation to each other, I'm still not clear on. Are you able to clarify that for us?
Not an exact timeline, Your Honor. What we know is that as soon as Ms. Zuniga began working at God's Grace Church, it was shortly after that she began experiencing these sexual harassing comments and the physical touchings without her consent. And we know that it occurred throughout the 19th month period that she was working at the church. As far as when exactly these events occurred, we're not quite sure. However, there is case law that supports that it is a question of fact for the trier of fact to determine when exactly this timeline of the harassing comments and conduct occurred.
But you acknowledge that it's different if we're dealing with 10 incidents happening one every other month or every 10 weeks over the course of 19 months versus having 10 happening right in that first month or right in that last month. Do you acknowledge that?
Yes, Your Honor. We acknowledge that the harassment continued throughout 19 months of employment. And we think that that makes it more significant because when Ms. Zuniga brought her claims forward about how these comments and the touchings made her feel objectified and humiliated and belittled, when she approached HR about that, they concluded that there was no investigation, nothing needs to be done. I'm sorry, there was an investigation, but nothing needs to be done as a result of that. Additionally, when Ms. Zuniga approached the church president, Mark Adams, with her concerns, he furthered that harassment with his comment back to her. He stated to her, your hips, breasts, and, I'm sorry, in response to your hips, breasts, and curves, Mark Adams said, I mean, he is correct. You have a very womanly body. Surely you can't expect men to just ignore it. It's in our DNA to notice beautiful females. You should just take it for what it is, a compliment. Not all the women who attend church can be so lucky as to get such attention. And that's on the record at page 23. We believe that comment alone furthers the harassment that Ms. Zuniga experienced. And when she brought this through appropriate channels, nothing was done. And Your Honor, we think that that particular instance is something that distinguishes itself from the case of Stacy v. Shoney's from 1998 out of the Sixth Circuit. This is a case that the appellee relies upon, but in that case, the court found that a supervisor's 2 months of suggested comments, leering, and even one instance of breast touching did not meet the threshold of severity or pervasiveness. The court wrote that the harasser's alleged comments were offensive, but not sufficiently frequent, severe, physically threatening, or humiliating to unreasonably interfere with plaintiff's work performance.
So how do you distinguish this case from the Stacy case?
Well, Your Honor, in that case, the plaintiff brought her concerns to their HR department, and they conducted an investigation. That investigation yielded nothing. However, no support for the allegations, rather. However, that HR department reprimanded the harasser, further offered the plaintiff an opportunity to go to a different store so that way she did not have to work with the harasser, and further said that if any more allegations are made, they would terminate the harasser. In that case, Your Honor, they took steps to prevent this harassment from continuing. In our case, Your Honor, they didn't. They did nothing.
But the conduct there seemed more egregious to me even than this case. It certainly struck me as more sexual, specifically sexual and breast touching as opposed to a hug or a brush or, I don't think anything rose to the level of somebody saying leering, or which was used in the Stacy case. I'm wondering, are you advocating a subjective standard if the person feels like it's severe and pervasive, that gets it, or does it need to be an objective standard?
Your Honor, when courts are assessing whether a hostile work environment was in fact rose to a severe and pervasive enough level, there is a subjective and objective test, and that's what all the courts endorse, including the Supreme Court in the case of Harris forklift. So you need to show that the plaintiff subjectively viewed this as a hostile work environment, and objectively that a reasonable person must as well. And we believe, Your Honor, that case law supports that a reasonable jury could find for Ms. Zuniga that these facts rose to a level of a hostile work environment.
One of the factors that must be considered in the totality of circumstances is interference with work. Is there any evidence in the record that these the alleged harassment actually interfered with her work performance?
Yes, Your Honor. So the factors include frequency of the conduct, its severity, whether it was physically threatening or humiliating, and whether it interfered with the employee's work performance. And Your Honor, after the investigation was done by our HR department, or God's Grace Church's HR department, the director, Talia Jones, noted that she noticed a decline in Ms. Zuniga's performance. She also noticed that the plaintiff became more isolated and less motivated. She began calling off of work because she did not want to be in an environment that was abusive towards her. And therefore, Your Honor, we believe that that shows that it affected how she was able to do her job, because she did not have these reviews before this investigation yielded nothing. But after the investigation did nothing, the church did nothing, she began, as I said, Your Honor, being less motivated, more isolated. And we believe that those are telltale signs of this plaintiff going into a depression. And Your Honor, in the case of Harrisburg Forklift, the Supreme Court noted that it is not a requirement that a victim of a hostile work environment show psychological abuse. However, what we know is that our plaintiff began receiving therapy after she left this job because of the harassment that she faced while she was at God's Grace Church. And additionally, Your Honors, that therapy was not covered by insurance. It had to be paid for out of pocket by Ms. Zuniga. And we believe that further shows that just that the harassment she endured had tangible, lasting effects. It was not fleeting, it was not just a moment, but this 19th-month period where she was objectified by people that she looked up to, it shows that it just made it worse for her. In another case, Your Honor, Kelly v. Senior Centers, this is a case that the appellee relies heavily on. And in that case, the Sixth Circuit found no hostile work environment where the plaintiff overheard racist or sexist remarks that were not directed at him, the plaintiff himself, and did not interfere with his ability to perform his job. The court emphasized that there is no evidence suggesting that Kelly was prevented from doing his job as a result of the comments. We believe that that Kelly case is distinguishable from the facts here for Ms. Zuniga. In that Kelly case, the plaintiff was not the object of these harassing comments or physical touchings. And moreover, Your Honor, it was not about his personal foster grandparents. It was about the program that he was working in. And therefore, just because these comments happened around him, it doesn't mean that it was a hostile environment for him himself. And in the case of Black versus Airing Holmes out of the Sixth Circuit in 1997, the court noted that in that case, most of the comments were not directed at plaintiff, a fact which contributed to the conclusion that the conduct was not severe enough to create an objectively hostile environment. In our case, Your Honor, there is these comments that were directed towards the plaintiff. Further, there was conduct, there was physical intrusions of the human body as these men placed their hands on her without her consent and gave her tight hugs, which made her feel like that was inappropriate, Your Honor. And briefly, in the case of Williams v. GMC.
So I'm sorry, is there not a world where a tight hug is part of the way a church just rolls? I mean, I don't know that there was any suggestion that somebody was seeking or receiving sexual gratification from the hugs, was there? I mean, there was no indicia of touching her breasts, or I think it said touching her back, but not a more sexually charged contact. What about that? I mean, that seems to me to backfill right into the ministerial. If a church is huggy, how do we get around that without doing a categorical bar here?
What the appellant believes you're referring to in that case, Your Honor, is church culture. And case law does not protect church culture. It protects church governance and the management decisions, the doctrinal decisions. Church culture, again, it's not protected. And further, Your Honor, the plaintiff went to other male coworkers and asked if they were experiencing the same treatment. And they said no. This means that the conduct was singled out towards Ms. Zuniga, as a female employee who they felt that they could take advantage of. And as I'm running out of time, Your Honors, I would like to wrap up. In sum, Ms. Zuniga faced ongoing, unwanted sexual harassment from the church's highest-ranking officials. She reported it through every available channel, and the church did nothing. The church may argue that its leaders used religious language, This case is not about theology. It's about power and harassment disguised as faith. The law requires that her claims be heard by a jury. And for these reasons, the appellant respectfully asks this court to reverse the district court's grant of summary judgment and remand for trial. Thank you.
All right, thank you. Response?
May I proceed?
Yes.
Thank you. May it please the court, my name is Chris Albert, and with co-counsel Devin Glaza, we are representing the appellee in this case, God's Grace Church. As opposing counsel stated, this case presents two core issues. One, whether the ministerial exception creates a categorical bar to hostile work environment claims. And two, even absent a bar, whether or not Ms. Zuniga was able to establish a prima facie hostile work environment claim. I will be addressing the first of these issues. The ministerial exception requires a categorical bar because it is not simply a policy preference, but it is a constitutional boundary rooted in our founding documents in both the First Amendment's free establishment and free exercise clauses. This was expanded upon by the Supreme Court's decision in the Hosanna Tabor decision when the courts recognized the exception to protect church autonomy by stating, quote, "The authority to select and control who will minister to the faithful is the church and the churches alone." The phrase select and control is key here. The court didn't stop at hiring and firing. It explicitly included control, the day-to-day management and internal governance of its own ministers. This principle was then expanded upon in the Our Lady of Guadalupe decision in 2020 by the Supreme Court, where it expanded the scope from hiring and firing to, quote, "the internal management decisions essential to the institution's central mission."
Counsel, before we continue down that line, I have a more fundamental question for you. The First Amendment argument, was that included in your affirmative defenses?
No, Your Honor, we did not offer an explicit religious justification for the conduct or for the speech explicitly. However, we contend that for a court to analyze the reasonableness or the totality of the circumstances of a workplace environment in a religious institution necessarily invites courts to second-guess ecclesiastical decisions and doctrinal considerations.
And so my question is, why not front load that? Why not put that in the affirmative defenses so that during the course of discovery, both sides can flesh that out? I mean, am I correct in understanding the first time that issue shows up in the record is in your motion for summary judgment?
That is correct, Your Honor. Although at trial that the affirmative defense for a religious justification was not presented, although the explicit justification is waived, we simply are contending that for courts to analyze a hostile work environment claim in the context of a religious institution invites churches to deliberate and parse out what exactly is religious enough and what conduct is not religious enough.
And that's your argument to get around waiver here?
No, Your Honor.
Assuming that the other side is going to say that, look, this issue is waived, you didn't include it in your affirmative defenses, why should we be addressing it?
Your Honor, because although that the affirmative defense was not applied, the question that we are presenting and that we are addressing is one of more of a constitutional harm that could happen under the Elvig and the partial ban framework, which is why that we, for a constitutional consideration, are advocating for the categorical bar to hostile work environments in the context of a religious employer.
Okay.
So counsel, what about the constitutional harm to employees and their right to be free from sexual harassment? It seems to me that if we adopt your position of a categorical bar, that would mean that anyone who chooses to work in a religious environment, chooses to work as a minister in a religious environment, would necessarily have to relinquish their right to be free from sexual harassment in the workplace. Isn't that the necessary result of your position?
Thank you, Your Honor. We would state that although on its face it may appear to be an arbitrary distinction, we would say that this is a constitutional boundary that is being created.
So the answer would be yes. If you're a minister working in a religious environment under the categorical bar, you relinquish your right to be free from sexual harassment.
Your Honor, we would say that it relinquishes the right to bring action under an HWE claim explicitly. If the conduct itself were to rise to the level of violating a generally applicable neutral law, such as a criminal statute, then religious leaders can be prosecuted. If it were to rise to the level of satisfying any number of torts under the common law, then then we are not contending that the categorical bar should also apply to torts or under the common law. However, only to the hostile work environment claims because of their unique occupation in American jurisprudence that necessarily invites the courts to evaluate the reasonableness and the hostility of a given environment. We contend that when a court begins to ask the question, well, what is reasonable for a religious institution, that in and of itself begins to invite the courts to determine, well, what is religious enough and what is not religious enough.
Counsel, to follow up on that, so if I hear you correctly, it would be fine for Zuniga to have sued your client for a civil battery.
Yes, Your Honor.
You wouldn't be raising these same arguments.
Your Honor, we believe that because the HWE claim, because of its unique occupation of having to evaluate the reasonableness of a work environment, we believe that whereas opposed to a common law tort such as battery, she would be welcome to bring that type of claim forward.
But for this case, wouldn't we get into some of the same issues about church culture and whether a hug is just a hug, or if it's harassment, whether it is actually an offensive touching that would satisfy a battery? It seems to me that you would have the same problems in a suit for civil battery as you would in the suit that we have right now. Functionally, what would be the difference?
Thank you, Your Honor. To my understanding, in regards to tort law under the common law, I have not seen a ministerial exception exuded as a defense to that, whereas in HWE claims and under ADA lawsuits, it's something that is presented regularly.
No, I understand that. What I'm asking is, from a practical standpoint, how would the discovery and trial look different in those two suits, a battery suit versus the one we have here? It seems that you would still be getting into a lot of the messiness of church affairs.
Your Honor, I believe that the difference would that be in a tort claim, the plaintiff would be suing the individuals for satisfying the elements of whatever this tort is, whether it be battery or intentional infliction of emotional distress. That's my understanding of what would be the distinguishing factor, whereas here, Ms. Zuniga is suing a religious institution, and in and of this lawsuit is questioning, inviting the courts to question the reasonableness of a religious environment.
But haven't there been several high-profile cases where plaintiffs have alleged negligent supervision of ministers who abuse children? Why are those cases allowed to proceed, but this one would be precluded? What's the difference?
Your Honor, I believe the cases in which you're referring, which involve child abuse, those were in violation of generally applicable neutral laws of violating criminal statutes. I believe that in those specific instances, ministers and church authorities were prosecuted under criminal statutes, not under HWE claims, which we would say that is a unique distinction between a criminal statute and the hostile work environment claim, insofar as a criminal statute is a generally applicable and neutral law, whereas the hostile work environment claim begs of the court to determine what is reasonable in a religious environment. We would implore this court to adopt what is both the modern trend and what has been the majority of circuits that have ruled on this decision in the 7th and 10th Circuits split. The 7th and 10th Circuits have adopted the categorical bar on the hostile work environment claims in the Demkovich and Skrichak decisions because they deem that courts cannot draw a workable line between tangible and intangible employment actions without necessarily entangling themselves into religious doctrine. The 9th Circuit attempted to carve out this intangible claim in the Bollard and Elvig decisions, but this requires secular judges to parse out exactly what is religious enough and what the First Amendment prohibits. Ms. Zuniga was a minister, and that is a settled case on the record on page 37, on the page 37 of the record. Her claim that we have here today is precisely the type that entangles a court into the sacred relationships between ministers and church authority. To evaluate whether her environment was hostile or reasonable, a secular judge would have to decide comments like your childbearing gifts are from God, whether they were theological reflections or unlawful harassment. To decide whether tight hugs or gestures between clergy are a part of a pastoral culture, or were they evidence of animus, or to assess whether a church's response, an internal HR investigation, which may be informed by doctrine, was an adequate remedy, or was it negligent? Each of those inquiries demands a secular evaluation of what is religious conduct and speech, and there's no way to do that without the church's doctrine about gender, ministry, leadership, and community to be asked the question of. The categorical bar for this court is not about excusing misconduct. It's about recognizing that the Constitution withholds jurisdiction from secular courts to resolve spiritual disputes. In regards to the constitutional harm and what we believe could be a perverse incentive that is created under the Elvig and Ninth District Court's partial ban, we believe that the partial ban provides an incentive for legal sophistication of churches so that they would become just learned in the law enough to know that at trial, all we have to do is provide a religious justification, and that's all we need to do. We believe that incentivization for legal sophistication in and of itself is a constitutional harm, and if not, it will incentivize churches to tailor their sermons, their theology, their practice, their day-to-day conduct to not be expressions of faith, but rather to be conduct that would survive litigation. May I have a brief moment to conclude?
You can wrap up this sentence, yes.
Thank you. Actually, that's all I have. Thank you, Your Honor.
Thank you.
May I proceed?
Yes.
May it please the court. My name is Devin Glaza, and along with my co-counsel, Chris Albert, we represent the appellee, God's Grace Church. Even if this court declines to adopt a categorical bar against Title VII hostile work environment claims under the ministerial exception, the alleged harassment does not meet the requisite severe or pervasive standard. And I would like to start off with stating that this court may not consider Ms. Zuniga's reduction of hours, the church's hiring of a new employee, or Ms. Zuniga's performance review when evaluating whether Ms. Zuniga has established a prima facie case of hostile work environment. These employment decisions are not subject to judicial review under Elvig's fact-based inquiry because they infringe on First Amendment free exercise and establishment clauses, which is why the ministerial exception was created. Therefore, we are only left with 5 alleged comments and 5 alleged physical contacts over the course of 20 months. There are 5 elements to establish a prima facie case of hostile work environment based on sex, and the church's position is that the 4th element is not met. That is, that the alleged harassment did not create a hostile work environment. A hostile work environment is one that is permeated with discriminatory intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the condition of the victim's employment and create an abusive working environment. A claim is evaluated both objectively and subjectively. The conduct must be severe or pervasive enough that a reasonable person would find it hostile or abusive, and the victim must subjectively regard that the environment is abusive. The church concedes that Ms. Zuniga subjectively believed that the alleged harassment was hostile, and it is well established that this court must consider the totality of the circumstances in determining whether an actual hostile work environment exists. There is no line or mathematical equation that determines what is severe or pervasive. Rather,
Counsel, that statement, though, isn't that an argument that this should go to a jury? If there's no line that determines severe or pervasive, that should mean that it should go to a jury for determination rather than the court as a matter of law.
not for this claim, Your Honor. This court's jurisprudence and the trial court's assessment of the alleged conduct conclude that only 5 comments and 5 physical contacts do not rise to the level of pervasive, and the content of the comments and the context of the touching are not severe. First, I would like to direct this court to Kelly v. Senior Centers, which establishes this circuit's standard, frankly, for pervasive. In Kelly v. Senior Centers, this case went to summary judgment. Here, the supervisors of the plaintiff referred to foster grandparents by the use of racial slurs. Additionally, very offensive language and crude, sexist, and racial comments were made to plaintiff. There were at least 7 total offensive comments made, and there were even allegations of a physical contact made by the supervisors to the plaintiff. However, the key and applicable language that this circuit held when they affirmed summary judgment in Kelly v. Senior Centers for the senior center is that the harassing conduct to be pervasive must be and occur on a daily or weekly occurrence. This court must find...
Counsel, you were saying that it's not a mathematical formula, but what you just gave us is it has to occur on a daily or weekly basis.
Correct, and that is where it comes into the totality of the circumstances. If there are, like in the case...
But that sounds like a bright line rule. What you're suggesting, if it's not daily or weekly incidents, then she hasn't satisfied her burden. We can be done here.
And that is the church's position, that only 10 alleged comments and contacts is certainly not pervasive. However, if those 10 alleged harassment were extremely severe, then maybe it should be sent to a jury. But that is not the case here either.
So if the church leadership had groped her 10 times over the course of 19 months, that would satisfy it?
Correct, or if it was over the course of 1 month. But today, those are not the allegations that Ms. Zuniga has presented. In addition, I direct this court to look at Stacy V. Shoney's. And to your point, Your Honor, the contact that Stacy presented in that case is certainly more severe than the contact that Ms. Zuniga alleged here today. In Stacy V. Shoney's, the plaintiff claimed that her supervisor, Kimbrell, inappropriately touched her breast and when he removed and replaced an ink pen and from her front shirt pocket and said, "That's a nice pen." This comment by Kimbrell clearly indicated, thank you, that the touching of her breast was not an accident. There was no accident. It was clearly an intentional contact made with her breast. And in addition to that contact, the manager at the Richmond Road restaurant began harassing her with sexually suggestive comments and leering looks. The court held that Kimbrell's alleged comments were offensive, but not sufficiently frequent, severe, physically threatening, or humiliating to unreasonably interfere with plaintiff's work performance to constitute an actionable hostile work environment. Most detrimental to Ms. Zuniga's hostile work environment claim is this case in Stacy, which concluded that a supervisor touching an employee's breast is not severe. So when we're not dealing with comments and contacts that are occurring on a daily or weekly occurrence like Ms. Zuniga alleges, only 10 total over the course of 20 months, and the severity of those contacts and comments do not even rise to the level of intentionally touching one's breast, how could this court conclude that it should be sent to a jury?
Counsel, when you're, the question that you add, the rhetorical question that you just end on, suggests to me that your idea is that the court should be judging the level of severity rather than the jury. Do I have that about right?
Correct.
And so what sort of framework do we use to address this is severe enough? 10 gropings obviously satisfies it. 10 hugs, I guess, obviously does not. But it seems that there's a wide spectrum of conduct in between that normally we would send that sort of thing for a jury to make inferences. Why is it different here?
The church's position is to follow this court's jurisprudence. In cases that have been sent to a jury, the facts are clearly distinct. In Smith v. Rock 10 Services, here the plaintiff experienced escalating harassment from a slap on the butt to simulated sex. The facts in that case were extremely severe, and the plaintiff also saw this conduct happening to other coworkers. And in this case, Ms. Zuniga only alleges, and no other employees have brought hostile work environment claims or alleged any harassment. That points to the workplace not having that permeated discriminatory hostile work environment that is required and looked at under the totality of the circumstance test. And in addition, in Williams v. GMC, another case that the Sixth Circuit reversed summary judgment, those facts are clearly distinct as well. There were 15 total allegations of harassment over 1 year, and the contacts that were made were violent and abusive. Williams had boxes thrown at her and hit at her. Those are contacts of the abusive and aggressive nature that are violent, and they're not merely offensive or deplorable. Those are the comments that need and contacts made that need to be sent to a jury. But that is not the case here today.
Under the totality of the circumstances, you're focusing on just a few elements of that entire analysis. There's no dispute, is there, that the conduct interfered with her work performance?
And that is correct. And additionally, looking at her performance review is barred even under a partial ban. So that is why we are only left with the 10.
But we can look at the impact on her work performance in the totality of the circumstances test to determine objectively whether or not the issue of severe and pervasive should go to a jury. If that factor is there, it all has various weight. We have frequency issues, but we also have physical touching here, which is not at issue or not as much of an issue in many of the cases. And we have, I believe, a concession that it did interfere with her work performance.
The church's position is that looking at her work performance and the objective standard that it takes to evaluate a minister's work performance is something that is held within the church. And even under the partial ban, that should not be considered by this court. So the church's evaluation of her work performance is something that this court should not consider. We are only left with the 10 total comments and contacts made.
So you're actually arguing for a modified totality of the circumstance test in addition to your other arguments, that because of the nature of this case having to do with a ministerial relationship, even if we get past the categorical bar, you believe we should also adopt a modified totality of the circumstances test?
The church's position is that and what I am arguing for is when only looking at if there is a partial ban, the totality of the circumstances can only look at the content and comments made within the workplace. And additionally, I'd point this court to the case of Middleton in the Sixth Circuit, where it was a hostile work environment claim made against a church. However, the Sixth Circuit held that there was no hostile work environment, and they said that poor management alone is not enough to establish a hostile work environment case. So we only left with the severity and the pervasiveness of the comments and contents. May I have a brief moment to conclude?
I think you're out of time, counsel.
Okay.
Thank you.
Thank you for your time, Your Honor.
Yep. Rebuttal?
May I proceed, Your Honor?
Yes.
Thank you. I have 2 points to make. First, as was addressed, the church did not assert a religious justification for their actions. Title VII was enacted to protect employees in their workplace, and Congress did not intend for ministers to surrender their right to be protected under Title VII. As was also noted in opposing counsel's address, the tort claims could be brought before this court. However, the ministerial exception could still be raised by individual supervisors, as was noted in the Conlin versus InterVarsity Christian Church Fellowship opinion. And we will still be right back here litigating the ministerial exception once again. Therefore, Ms. Zuniga should be protected by Title VII, as Congress intended to be able to protect churches' rights to be free of governmental interference, while simultaneously protecting those that are employed by the church. Second, as was also noted in opposing counsel's response, there is not a line that has been drawn as to what is severe or pervasive. This court, along with the Fourth and 10th Circuits, have consistently recognized that whether harassment is sufficiently severe or pervasive enough to rise to the level of a hostile work environment is quintessentially a question of fact. Therefore, it should be sent to the jury so they can decide this question of fact, Your Honor. Respectfully, we ask that this court find that the ministerial exception does not create a categorical bar, and we ask that this court reverse the district court's grant of summary judgment. Thank you.
Thank you. Counsel well argued. The case will be submitted. We'll be in recess.
All rise. You may be seated.
Please have a seat. Okay. First off, as the presiding judge for this affair, I want to thank you all for your preparation and the time that you've put into this and how seriously you've taken this. It's obvious. And I'll front load this by saying the conversation during our deliberation started with us saying the arguments that we just saw kind of rival some lawyers that we've seen argue. And so you all should all be proud of that. Obviously, there can only be one winning team, but the fact that you've made it this far, I think, is a testament to how well you've done and how well I think we can all expect you to do. So I congratulate all four of you on that.
It really was unanimous. All three of us said we've seen counsel not do nearly that well where they were working for paying clients. So,
Yeah. Okay. And with that, I can announce the winner of this year's competition. The winning team goes to appellant, Ms. Wendt and Ms. Bennett. Congratulations. And I'm pleased to announce the award for Best Advocate goes to Haley Bennett. Congratulations. This being a moot court competition, I think it's reasonable to expect some level of feedback. And so we're happy to provide that in this context. I'm sure that each of us would be willing to offer more granular feedback afterwards, but I think it's helpful for everyone sitting here to hear a little bit of what our reactions were. So maybe we can go right down the line. You want to get us started?
Well, again, you all did so well. I really hope that all of you go into appellate advocacy in your professional endeavors, because we were just really impressed with your performance. And I mean, generally speaking, you could tell that when each of you got up to the podium, there were some nerves at first, but that's natural and that's normal, and that, I hate to tell you, but that probably isn't ever going to go away, even in your practice as attorneys. But you all got past those initial nerves and had a good presence at the podium. You dealt with questions well. We gave you probably the hardest questions that came off the bench today, and you handled them very, very well. And probably some unexpected questions, and that's going to happen in practice as well. And just remember to not be wedded to your notes, and to try and really be in the moment with the judges, because it's as much a conversation with us to try and alleviate any questions and concerns that we have. I'm trying to think.
so I'll just offer a couple of things. Amanda, it's hard to go first, you know, but you did great. You came out of the blocks. I think, initially, as would be expected, I think you started off a little bit tight, but you then got into the moment and did a great job. Rebuttal, that's the chance. I mean, that's the bottom of the ninth with three runners on, and you got up and you did exactly what you needed to do, no more, no less, and that's a skill set. That's a skill set that you can't write your rebuttal before the argument. It's got to be in the moment, and I think if you wrote that ahead of time, don't tell me, because I sure didn't think you did. I thought you did exactly what, and I think there was some consensus that you really did a nice job with your rebuttal. Haley, you really had command and just great eye contact, because you have an opportunity when you're talking to the three judges who are going to decide for you. I think you did a really good job of connecting with each of us and making some eye contact and looking for maybe a cue. Even when a judge isn't asking a question, you might be having a conversation with that judge, whether you know it or not. And I think you at least presented to me that you have that sort of sense of how to do it. I think the one constructive criticism I might say is if you get asked a question, do your darndest to just answer the question without going back to, and here are the three factors that you gotta, just get right on it. But you did that exactly one time. Otherwise, you were right on the questions, and I think, we had it wasn't a hot bench, but it was certainly a warm bench going on up here, and you did a great job. Chris, I thought you did a great job of just owning the room. You got a future in this, man. I'm just telling you. You got up there and you owned it, and I think you did get you got the worst barrage of questioning. Okay, but I think you did a great job with that. If allow yourself to take. I think at one point you were afraid to take a position that you were invited to take, and I don't remember exactly what it was, but you sort of backed off on something where I think it might have been more effective to just go there. All right, and Devin, you did something that I love, which is you responded to a question that was asked of the other side. Right? I mean, I think you did that, and I think that is monstrously effective. Okay, because obviously at least one of the judges thinks it's important. So rather than just talking about what you want to talk about, coming in there and answering a question that was asked to the other side, I think it's huge. And if you got a chance to do that once, twice, three times, however many times you do it, I think you were really good. That was a home run for me when you did that. So it wasn't just because it was my question. But anyway, Noah.
No, I would echo all these comments, Mr. Glazer. That is something that it works really well, and you can put that in your toolkit. You can, depending on how comfortable you are doing it, say, well, Your Honor, I want to answer the wise question that you asked my colleague that they refused to answer. And then it kind of, depending on your comfort level with that. I would get more comfortable away from the notes. It's obvious that you know the facts of this case and you know the law of this case. But as Judge Knapp said, reading the bench and seeing how engaged or disengaged a judge is with your case, it can be vital at times. Mr. Albert, I think the consensus is you got the hardest questions. They may not have been questions that were front and center in the prompt here, but that's real life, right? That's how it will be in practice. You had good responses to the waiver issue, to the battery question, and those are things where it may not have been covered in your brief. That's the point of oral argument, which is to give the judges more contexture about what's going on in the case. Ms. Bennett, again, very comfortable presence. It seemed like you weren't really referring to your notes hardly at all. That's good. I have here that you dealt well with interruptions and good responses to the questions. Ms. Wendt, again, the rebuttal was excellent. The best rebuttals that I've seen have been a matter of seconds, right? Where someone gets up, and this is the last thing you're going to hear about this case before you go back to conference and deliberation. I thought it was very well done. Each of you, fantastic job.
You all set?
Yeah, that's it. Unless your honors have anything else to add.
No, with that, we're adjourned. All
No,
right.
it really was a close call across the board, and you're all to be congratulated for making it this far, and please keep after it, because you did great. Okay.
Great job.